Welcome to another online PowerPoint presentation. I am Stephen Teal, Partner and Director of Legal Research at Gardiner Roberts, LLP. I have been a research lawyer for almost 30 years. In this presentation, I will be reviewing a recent decision from the Ontario Superior Court of Justice, in which lawyers for Gardiner Roberts, LLP were able to have a Mareva Injunction continued against a corporate and a personal defendant. The case was Associated Foreign Exchange Inc., or AFEX for short, versus MBM Trading. While the facts of every case are important, this presentation will emphasize the test that a moving party must meet in order to obtain a Mareva Injunction, and the procedural steps that usually take place when a party seeks such an injunction. But first, it is important to understand what a Mareva Injunction is. The Mareva Injunction is an equitable remedy that generally is sought to freeze the assets of another party before the final disposition of a case. It is therefore a form of pretrial remedy and is usually obtained very early on in a proceeding. Freezing a person's assets can have harsh consequences, and therefore the remedy is considered to be extraordinary. The name of this injunction is derived from the 1980 English case of Mareva Compagnia Naviera S.A. versus International Bulk Carriers S.A. Now, a Mareva Injunction is usually obtained ex parte, or without notice to the other side. The reason for this is to ensure that the defendant is completely unaware of the plaintiff's action and his or her move to freeze the defendant's assets. It is believed that if a defendant is made aware that a plaintiff will be bringing an action against the defendant or will be seeking to freeze the defendant's assets, the defendant will take steps to dissipate his or her assets or hide them from the eventual reach of the plaintiff or a court. In order to get the injunction, the plaintiff is required to meet a stringent test. We will look at this test more closely in the next slide. For now, what is important is that the ability to obtain an ex parte injunction is governed by Rule 40 of the Rules of Civil Procedure. The plaintiff will first issue the statement of claim and then usually immediately bring the ex parte motion for the injunction. Under the rules, an ex parte injunction can only be granted for a maximum of 10 days. Therefore, to ensure that a Mareva Injunction remains in place during a proceeding, the plaintiff must generally bring a continuation motion to extend the injunction. This motion must be made on notice to the defendant. The test for obtaining a Mareva Injunction is fairly well established in Ontario and Canadian law. One of the leading cases in Ontario law remains Chidle v. Rothbard. The case law establishes that in order to obtain a Mareva Injunction, the plaintiff must show that he or she has a strong prima facie case, that he or she will suffer irreparable harm if the injunction is not granted, and that the balance of convenience weighs in favor of the plaintiff. The plaintiff must also show that there is a serious risk that if the Mareva Injunction is not granted, there is a risk that the defendant will either remove them from the reach of the court or dissipate them. In general, the plaintiff will also be required to give an undertaking in damages in order to get the injunction. This is an undertaking which is given to the court. As stated earlier, after an ex parte injunction is granted, the plaintiff must then have it continued, since an ex parte injunction only remains in force for a maximum of 10 days. On a continuation motion, the court hears the matter afresh or de novo. The judge hearing the motion is allowed to consider the original record that was placed before the court on the ex parte motion, and any material filed on the continuation motion, including affidavits placed before the court, transcripts of any examinations on the affidavits, and any other evidence that has been obtained between the granting of the ex parte motion and the hearing of the continuation motion. In AFEX, the court found that the plaintiff had met this requirement. The plaintiff must again satisfy the injunction test and demonstrate once again that the assets will either be removed or dissipated if the injunction is discontinued. The court is also entitled to examine whether, in obtaining the original injunction, the plaintiff made full and frank disclosure to the court. On the ex parte motion, the plaintiff must disclose to the court all relevant material facts related to the claims and available defenses. If it is shown that the plaintiff did not make full and frank disclosure on the ex parte motion, the plaintiff will forfeit his or her right to a Mareva injunction. A significant issue in this case was whether the Mareva injunction could be issued because there was no evidence that either the corporate defendant, MBM, or its president or controlling mind had assets in Ontario. The plaintiff was able to show that these defendants had assets in Quebec. While the defendants argued that having assets in Ontario was one of the necessary elements of the Mareva injunction test, the plaintiff argued that there was no longer a requirement for a defendant to have assets in Ontario. The plaintiff relied on Borelli v. Chan and argued that the law had evolved in the almost 40 years since the seminal case of Cheitel and Rothbard, given the global economy, and that to require a defendant to have assets in Ontario would mean that a plaintiff would have to commence a proceeding in every jurisdiction where a defendant had assets, or that a party's credit would be limited to jurisdictions in which they had assets. The court agreed with the plaintiff and relied on Section 101, Sub 1 of the Courts of Justice Act, which provides that an interlocutory or mandatory order can be granted where it appears to a judge of the court to be just and convenient to do so. Since a Mareva injunction is an equitable remedy, it evolves as facts and circumstances merit. In this case, the court found that there was a prima facie case involving a series of 6 foreign exchange trades made over a 5-day period which were not paid for because of insufficient funds into bank accounts. Despite assertions that the plaintiff would be paid, the evidence showed, among other things, that money was being paid to another creditor by the defendant. The defendant also admitted that assets were being dissipated. With respect to irreparable harm, the court found that such harm extended to the possibility that a plaintiff might not be able to realize on a future judgment. While the president of MBM said that he had enough assets to take care of everyone and that the plaintiff would be taken care of, nothing had been repaid to the plaintiff or even into court. Lastly, the evidence showed that neither the impugned corporation or its president were particularly inconvenienced by the injunction. The balance of convenience thus favored the plaintiff. The plaintiff in this case was represented throughout by Gavin Ty and Scott Gefeller. Gavin is a senior litigation partner at Gardiner Roberts and a certified specialist in civil litigation. Scott is a litigation partner at the firm. I assisted with legal research on certain issues raised in this case and helped to draft the written argument filed with the court. Thanks for watching this presentation. This presentation is intended for legal educational purposes only and is not intended to be relied upon in any manner whatsoever as legal advice. Any opinions expressed in this presentation do not represent the views of Gardiner Roberts. Don't forget to like this presentation and to subscribe to our YouTube channel.